Probate is a court process where the judge sits essentially in a role as referee to make sure that property goes to the correct people. Now, the correct people are either first, the people who are listed in a will, or second, the people who inherit according to the law as it's set out in the probate code. Now, the process is that the person named the executor or another interested party will file a petition to probate the will. Once that petition is filed, there are certain intermediate court hearings and deadlines that have to be followed. Once those hearings and deadlines occur, the executor will file a request to distribute the assets and to close the estate. On average, it takes anywhere between 18 and 24 months for a probate case to go through the court process. Probate is required whenever somebody dies with more than $188,000 in his or her name. Now, this is the gross value of the asset or the fair market value of the asset on the date of their death without subtracting any debts. And so if somebody owned a home, even if the home had a sizable mortgage, they will probably have to go through probate. Probate is required regardless of whether there is a will or not. So if someone has a will and they own more than $188,000, their estate will still have to go through probate. Well, there are several categories of assets that are not included in probate in California. The first category are assets that are owned by a revocable trust. If someone created a revocable trust during his or her lifetime and transferred assets to that trust, then those assets that are owned by the trust are not part of the probate case. The other class of assets that are not part of a probate case are assets where there is a designated beneficiary. So an example of these will include life insurance and most retirement accounts. A third category of assets that are not included in a probate case are assets that are held jointly, such as a joint checking or savings account. The law says that when one person dies on a joint financial account, the other person is the sole owner by operation of law. And so those types of assets, the jointly owned assets, most retirement accounts or beneficiary designated assets, and any assets that are held by a revocable trust are not part of the probate estate. The answer is yes. Probate is a public proceeding in the Superior Court in California. What that means is that the will of somebody who recently passed away gets submitted to the court, and that becomes a public record. The last thing that the executor does in a case before the court distributes the assets to the beneficiaries is to file an inventory of the assets, which lists out all of the assets that the decedent owned on the date of his or her death and the value of those assets. That inventory and appraisal, as it's known, is also a public record. And so you have the will, which is who gets what, and then you have the inventory and appraisal, which lists out what the assets are and what their value is. And that is a lot of financial information to have in the public domain. In fact, one of the main motivations for most people to do estate planning is to avoid the public nature of probate. And the short answer is yes, it is expensive in most cases relative to doing other types of estate planning that might help you avoid probate. The fees that are charged in probate are first, the executor is entitled to be paid for his or her service of being the executor of the probate estate. The reason for that is being the executor is a lot of work. The fee that the executor is able to be paid is a percentage of the gross estate value. What that means is it's the fair market value of all of the probate assets on the date of death of the decedent without subtracting any of the debts. And so if someone owned, for example, $1 million house, but it had an $800,000 mortgage, the probate fee would be based on the $1 million fair market value of the house. Now, the percentage is a stair-step down percentage. So it starts at 4% and it decreases as the value of the assets increase. And it's a percentage that is based upon each level or each value of assets. And so, for example, it's 4% for the first 100,000, 3% for the next 100,000, 2% of the $200,000 to $1 million, and so on. For a $1 million estate, the probate fee is 2.3%. Now, the second cost of probate comes from attorney's fees. The probate law says that an executor can hire an attorney to help him or her, and the attorney is paid in the same way as the executor is, as a percentage of the gross estate value. And the percentages are the same. So, for example, with a $1 million estate, the executor would receive 2.3% or $23,000, and then the attorney would also receive 2.3% or $23,000 on a $1 million estate. And so this is significant amount of money and cost to have someone's estate go through probate. California defines a small estate as someone who passes away with less than $184,500 in his or her name on the date of death. Now, that number does not include real estate. And so if someone owns real estate in California, it's unlikely that they can avoid probate if they haven't done prior planning. If someone does not own real estate and they have an estate that has a value of less than $184,500, then they can avoid probate by signing what's called a small estate affidavit. And the answer is, it depends. If the beneficiary is the surviving spouse, then the surviving spouse may do what's called a spousal set-aside procedure, which is a short form of probate. If the beneficiary is not the surviving spouse, but is an adult child or other family member, then it's likely that a probate case will be required. If the beneficiary is the surviving child who is not yet an adult, meaning the beneficiary is a minor child under the age of 18, then a probate case is definitely required. The answer in most cases is no. The purpose of probate is to make sure that property gets to the correct people after a decedent has passed away. If the decedent did not have property in his or her name when they died, or if the property was held jointly with another person such that it passed to that other person automatically, in those circumstances, there is no need for a probate case. Well, if a house is in probate, what that means is that it is one of the assets that was owned by the decedent, the person who passed away, upon his or her death. And a probate case was started and the house was listed as one of the assets of the probate estate. And so what that means is that the court has authority and oversight of the house, and generally the executor has to get the court's approval before the house can be sold. In other words, the house is part of a court case, and the judge ultimately will decide whether the house can be sold or not. And the answer is yes, but you need to get the court's approval in most cases before you do so. Having a house in probate means that the house is one of the assets of the decedent, the person who recently passed away, and the house is now part of the probate case and under the jurisdiction of the court. Generally, the executor is the person who is responsible for making sure that assets are first marshaled or determined to be the assets of the decedent, and then the assets ultimately are distributed after the court says it is okay to do so. So you can sell a house that is in probate as the executor. You just need to get the judge's authority to do so first most of the time. There are two types of probate in California. The first is probate when there's a will. The second type is probate when there is no will. And that's what's called an intestacy proceeding. Somebody dies intestate or without a will. Having a will does not avoid probate. There are only three ways to avoid probate in California. The first is to have a revocable trust. The second is to be married and have a surviving spouse do what's called a spousal set-aside. And the third way is to have a small estate, which is having less than $188,000 in assets on the date of your death. Now, probate if there is a will and probate if there is not a will are very similar to each other. It starts when someone files a petition with the court. If a will exists, they have to attach a copy of the will and ask the court to admit the will into probate. If there is no will, then that person is said to have died intestate, which means dying without a will. When that happens, the property is ultimately distributed by the court to the people who are listed in the probate code. That is usually a surviving spouse if there is one, surviving kids. If there are no surviving spouse or surviving children, then it generally goes up the family tree to the parents and then out the branches to the siblings. So if there is no will, probate works very similar in California to the situation if there was a will. It involves a court process with the court having oversight to make sure that property gets distributed to the correct people. One of the best ways to avoid probate is to set up a revocable living trust. When you set up a revocable living trust and transfer your assets to that trust, you can avoid probate for the assets that are owned by the trust. If you have questions about estate planning and would like to discuss this more, please click the link or contact us through our website. I'm Matthew Kreider, and thank you for watching.